President Trump has signed an executive order clarifying the scope of birthright citizenship, much to the outrage of the progressive woke community specifically and the third world generally. Those who oppose Trump are arguing that the 14th Amendment automatically grants United States citizenship to everyone born on American soil, no matter what. But is that what the 14th Amendment really says? To allow any and all of the 9 billion people on the planet, none of whom have any allegiance to the United States, to birth children on U.S. soil who then instantly become American citizens? Are we supposed to simply accept that the 14th Amendment is effectively a mechanism of national self-destruction? I think not. And I'd like to explain why by using the actual history of the 14th Amendment itself. First, what is the 14th Amendment and why does it matter in this discussion of so-called birthright citizenship? Well, the 14th Amendment includes 4 separate clauses, but only the first touches on this issue of birthright citizenship, and it reads, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." Now, factions that would benefit politically and economically from the United States becoming awash in billions of third world migrant invaders popping out offspring on American soil claim that a plain English reading of the 14th Amendment allows for precisely that kind of unlimited birthright American citizenship. So does that settle the question? Fortunately not, because our nation is not some idiotic automaton bound to abide by any language twisted to its own national destruction. Let me give you an example. Way back when Thomas Jefferson was president of the United States, he faced precisely this kind of self-destructive plain English reading dilemma. He was faced with a choice: strictly abide by some legal language at the cost of causing America enormous harm on the one hand, or acting in the interest of the nation he led, even if it meant violating the technical legal language in question on the other hand. Not being an idiotic automaton, Jefferson naturally acted in America's interest and contrary to the technical language of the law. He later wrote, quote, "A strict observance of the written law is doubtless one of the high duties of a good citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger are of higher obligation. To lose our country by a scrupulous adherence to the written law would be to lose the law itself, with life, liberty, property, and all those who are enjoying them with us, thus absurdly sacrificing the ends to the means." In other words, the Constitution is not a national self-destruction pact. If national self-destruction would be the consequence of slavishly following a plain English reading of the Constitution. Other American political leaders have made similar pragmatic choices and acted upon them, including President Abraham Lincoln when he suspended the constitutional prerogative of habeas corpus during the Civil War. So even if the men who drafted and adopted the 14th Amendment intended it to mean that all 9 billion of the world's population, utterly lacking in any connection to America or its history or citizenry, could simply invade our nation and drop instant American citizens out of their wombs, promptly replacing America's historical and cultural population, even if that were their intent, America in 2025 would be under no moral or legal obligation to follow that policy if doing so meant the effective destruction of our nation, as it surely would, and quickly. That said, it should be obvious that the men who adopted the 14th Amendment intended nothing of the sort. They valued America as the unique political institution and cultural nation it was. They knew America was exceptional in those respects. In fact, rather humorously, during the Senate debate on the 14th Amendment, Senator Cohen emphasized that American society was deserving of preservation from the chaos of immigration from quite different foreign cultures, noting, quote, "If California was likely to be invaded by a flood of Australians or people from Borneo, man-eaters or cannibals, if you please, she would have the right to say that these people should not come there. It depends upon the inherent character of the men. Why, sir, there are nations of people with whom theft is a virtue and falsehood a merit. There are people to whom polygamy is as natural as monogamy to us. It is utterly impossible that these people can meet together and enjoy their several rights and privileges which they suppose to be natural to the same society. And it is necessary, a part of the nature of things, that society shall be more or less exclusive. It is utterly and totally impossible to mingle all the various families of men, from the lowest form of the Hottentot up to the highest Caucasian, in the same society. In other words, he's saying diversity is not only not our strength, it is societal self-destruction. And America had the obvious authority, bedded in self-preservation, to maintain its relatively homogeneous, high-trust society by both controlling immigration and constraining to whom citizenry would be recognized. Is that not equally true today? Is America better off today in 2025 than it was in, say, the 1980s or the 1990s, when we were far less culturally diverse? Food for thought, right? In any case, like every other nation on earth, America made use of the concept of citizen specifically to distinguish between people who possessed that quality and people who didn't. American citizenry wasn't simply possessed by everybody in existence, but only by a relatively few, and them for specific reasons and under specific conditions. Indeed, during consideration of the 14th Amendment, there were serious and substantive debates around the concept of American citizenship and who should possess it and under what circumstances. And that history and debate makes clear that what the adopters of the 14th Amendment were contemplating about birthright citizenship is not simply that any invader or visitor to our border could birth offspring and have that offspring qualify automatically as an American citizen. Well, you may be wondering, why does it matter what the adopters of the 14th Amendment were contemplating? We have the plain language of the 14th Amendment right there before us. Again, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Can't we just read that, make our own interpretation, and be done with it? Well, the answer is no. And the reason the answer is no is because any agreement, and the legal term for an agreement between parties is what's called a contract, any agreement, in order to be morally and legally valid, requires what's called a meeting of the minds. That is, both parties have to be in substantive agreement about what the mutual terms and conditions of the agreement are, or it's unenforceable. A contract that is merely deception or manipulation or even just misunderstanding is not a contract at all. The 14th Amendment, like every amendment, like the Constitution itself, is a form of agreement by the parties who are bound to it. So what the parties to that agreement were contemplating is not just relevant, it controls the actual moral and legal scope of the agreement. To be explicit, what the adopters of the 14th Amendment were actually contemplating is more controlling on the scope of the amendment than is any later day interpretation of the amendment's language that would be inconsistent with their meeting of the minds. Context matters. Indeed, the context controls everything. So what was the context around the 14th Amendment? Well, we're lucky to have insight into this because we have records of the Senate debates around the 14th Amendment, largely captured in the congressional records of the debate from 1866, when the language of the amendment was being finalized, and 2 years before the final form of the amendment was ratified. I've included a link to the relevant congressional records in the description of today's show. Essentially, it consists of 8 pages from the Congressional Globe that all look more or less like this. And throughout this debate in 1866, it's clear that all of the parties agreed explicitly that the rule of birthright citizenship to be created by the 14th Amendment was literally not that merely being born on American soil was alone enough to gain American citizenship. At the very start of the debate, Senator Howard notes that, quote, "This 14th Amendment, which I offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States." Now, this might sound like the very broad definition of birthright citizenship currently being pushed for by migrant advocates. Senator Howard, however, immediately in the next sentence follows this up by noting that not everyone born in the United States would automatically be a citizen. Quote, "This will not, of course, include persons born in the United States who are foreigners, aliens, or who belong to the families of ambassadors or foreign ministers accredited to the government of the United States. So right at the start of this debate is a recognition that someone can be born in the United States and yet still be a foreigner who would not be recognized as a citizen despite having been born in the United States. That should put to bed any claim that merely being born on American soil makes one an American citizen. Now, that quote of Senator Howard has been widely making the rounds on social media and would seem to settle this question of whether or not being born in the United States is alone sufficient for citizenship. Clearly, Senator Howard says it's not. When I saw that particular quote, however, I wanted to make sure it wasn't being taken out of context. After all, that's only one paragraph from one senator, and there are a total of 8 pages of record involving numerous senators. So I did the reasonable thing and carefully read all 8 pages of the 14th Amendment debate to see if there was any substantive disagreement, even a scintilla of disagreement, with the proposition that birthright citizenship would obviously be restricted only to particular classes of people, and that simply being born in the United States by itself was not sufficient. It was undisputed in the 1866 debate that up to this point in American history, merely being born on American soil was not enough to make one a citizen. Senator Cohen in the debate said, quote, "It is perfectly clear that the mere fact that a man is born in the country has not heretofore entitled him to the right to exercise political power of citizenship." So merely being born on American soil was not enough to be deemed an American citizen. Something more than that is required. And in fact, the 14th Amendment recognizes this and includes the additional condition, in addition to being born in the United States, of and subject to the jurisdiction thereof. Remember, the 14th Amendment reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." Now, modern advocates for broad birthright American citizenship for the whole world argue that this condition of subject to the jurisdiction thereof simply applies to everybody within the borders of the U.S. After all, anybody in the U.S. of any status is obliged to obey the laws of the United States. They can be brought before a United States court and so forth, much like any of us visiting France would be subject to the jurisdiction of France. But it should be obvious that subject to the jurisdiction thereof, as used in the 14th Amendment, has to mean something more than simply being obliged to obey American laws because you're within America's borders. Because if that's all it meant, the phrase, "and subject to the jurisdiction thereof," would simply be redundant with the first requirement of having been born in the United States. When you're born in the United States, well, you're physically present in the United States and are already obliged to obey American laws. The only logical reason to add the additional phrase, "and subject to the jurisdiction thereof," to the phrase "born in the United States," is if "and subject to the jurisdiction thereof" means something more, and in addition to merely being obliged to obey American laws. As a matter of basic legislative interpretation, it is assumed that every part of a law is present intentionally and for purpose, and is not merely redundant. Fortunately, we don't have to wonder about whether the 14th Amendment requirement of "and subject to the jurisdiction thereof" means simply having to obey the law, because the debate makes instantly clear that it means much more in the context of birthright citizenship. In fact and law, it was understood and agreed in those debates that "and subject to the jurisdiction thereof" meant "and subject to the complete jurisdiction thereof," with no allegiance to any other foreign nation. As described by Senator Trumbull, quote, "The provision of the 14th Amendment is that all persons born in the United States and subject to the jurisdiction thereof are citizens. That means subject to the complete jurisdiction thereof." What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. Now, that means that anyone who has a citizenship allegiance to any other nation, by definition, does not qualify under the condition of and subject to the jurisdiction thereof of the 14th Amendment for purposes of birthright citizenship, because a foreign national is also subject to the jurisdiction of their home nation and not completely to the United States. And again, this discussion would not even have occurred if simply being born in the United States alone automatically qualified as being subject to the jurisdiction thereof for Fourth Amendment purposes of citizenship. After all, the entire discussion is framed in the context of born in the United States already. In speaking of the Native American Indians, Senator Trumbull noted, quote, "It cannot be said of any Indian who owes allegiance, partial allegiance, if you please, to some other government, his tribe, that he is subject to the jurisdiction of the United States." He also said, quote, "It is only those persons who come completely within our jurisdiction that we think of making citizens." Quote, "I have already replied to the suggestion as to the Indians being subject to our jurisdiction. They, members of tribes, are not subject to our jurisdiction in the sense of owing allegiance solely to the United States. They would not be embraced by this provision of birthright citizenship of the 14th Amendment." Senator Johnson, in the same debate, noted, quote, "Now, all this amendment provides is that all persons born in the United States and not subject to some foreign power," for that no doubt is the meaning of the committee who have brought this matter before us, "shall be considered as citizens of the United States." This makes explicit that it is possible to be born in the United States and be subject to some foreign power, or none of this would need to be discussed. Senator Howard in the same debate noted, quote, "I concur entirely with the honorable senator from Illinois in holding that the word jurisdiction, as here employed for purposes of citizenship, ought to be construed as to imply a full and complete jurisdiction on the part of the United States. Certainly, gentlemen cannot contend that an Indian belonging to a tribe, meaning owing allegiance to some other national power, although born within the limits of a state, is subject to this full and complete jurisdiction for purposes of citizenship. That question has long since been adjudicated so far as the usage of the government is concerned." And Senator Williams in the same debate noted, "In one sense, all persons within the geographical limits of the United States are subject to the jurisdiction of the United States, but they are not subject to the jurisdiction of the United States in every sense. Take the child of an ambassador. In one sense, that child born in the United States is subject to the jurisdiction of the United States because if that child commits the crime of murder or commits any other crime against the laws of the country, to a certain extent, he is subject to the jurisdiction of the United States, but not in every respect. I understand the words here, subject to the jurisdiction of the United States, to mean fully and completely subject to the jurisdiction of the United States." And Senator Salisbury in the same debate made clear that the purpose of the 14th Amendment was to make citizens of the freed slaves and not to make citizens of others born on American soil who have allegiance to other sovereign powers. He argued, quote, "I do not presume that anyone will pretend to disguise the fact that the object of this section, birthright citizenship, is simply to declare that freed slaves shall be citizens of the United States. There can be no other object in it." In fact, it's uncontested that the primary driver behind the 14th Amendment, passed alongside the other civil rights amendments following the Civil War to end slavery, was to provide citizenship to the millions of freed slaves who would otherwise have been left stateless and without any citizenship whatever. This rationale obviously does not apply to people who already possess citizenship to some foreign power, as the Native Americans did to their tribes, and as immigrants from foreign nations did to their home nations. It's notable that this Senator Salisbury is the only participant in the debate who makes any suggestion favorable to making even Native American citizens, noting later that, quote, "If these freed slaves are to be made citizens of the United States, I can see no reason in justice or in right why the Indians should not be made citizens. If our citizens are to be increased in this wholesale manner, I cannot turn my back upon that persecuted race." Now, note that this consideration is specifically to Native Americans who were present in America for thousands of years before the settlers arrived, and with whom the Americans had already had a long coexisting relationship. This consideration was explicitly not extended to the world at large. So at this point, I've covered all 8 pages of the 14th Amendment Senate debate as recorded in the congressional record, and in every instance in which the question of birthright citizenship was discussed, the following were uncontested and represent the true meaning of the minds and the genuine meaning of the 14th Amendment statement that people born in the United States and subject to the jurisdiction thereof are American citizens. First, merely being born in the United States alone is not sufficient for American citizenship. You also have to be subject to the jurisdiction thereof. Second, being subject to the jurisdiction thereof of the United States for 14th Amendment purposes means being exclusively subject to the complete jurisdiction of the United States and the absence of any foreign citizenship or allegiance. Third, the offspring of parents with an allegiance to a foreign power presumptively inherit their parents' foreign allegiance. Fourth, and in conclusion, offspring born with an inherited allegiance to a foreign power are not, for 14th Amendment purposes, subject to the complete jurisdiction of the United States and do not qualify for birthright citizenship, even if born in the United States. So that's it, folks. Case closed. The notion that the 14th Amendment was intended to provide instant American citizenship even to the offspring of citizens of foreign nations or people who illegally invaded American soil, merely because those offspring were born in the United States, is utterly unsupported by the history of the 14th Amendment itself and is trash, trash, trash. And I expect that's how a rational Supreme Court, when faced with this question, will resolve that matter. Now, I should mention that it's possible that the offspring of citizens of foreign nations who have been granted permanent residency in the United States, green card status, as opposed to temporary visa holders or illegal invaders, that permanent residents would be treated more favorably in terms of birthright citizenship. This was the successful argument made in the 1898 Supreme Court decision of U.S. v. Wong Kim Ark, a 7-2 decision of the Supreme Court. But that would be a matter of public policy preference, not a requirement of the 14th Amendment birthright citizenship. So it's really a topic for another day. I'll also note that the 7 justices who voted for birthright citizenship for children born to non-citizen permanent residents in that 1898 case of Wong Kim Ark, those were the same justices who voted in the majority decision of the infamous 1896 case of Plessy v. Ferguson that established racial, separate but equal education, bus seating, water fountains, and much else as the law of the land until Plessy was reversed in 1954. So perhaps that panel of 7 justices is not the most difficult to reverse in the history of the Supreme Court. Finally, I'll note that much of the loudest screaming I'm hearing about Trump's clarification of 14th Amendment birthright American citizenship is coming from the many tens of thousands of Indians, Asian Indians, present in the U.S. on temporary H-1B and student visas who mistakenly believe that their children born in the United States automatically qualified as American citizens. I'll note that under the laws of their own nation, India, people born in India do not qualify as Indian citizens unless at least one parent is also an Indian citizen. And now you know the rest of the story. All right, folks, that's all I have for you on this topic. Hopefully this settles this question. Until we meet again, I'll remind all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself to know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca at the Law of Self-Defense. Stay safe. I want to give you a free copy of our best-selling book, The Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. We translate all the legalese into plain English so you can make better informed, more confident, more legally sound, and more decisive decisions in defense of what you value most. And perhaps best of all, most people tell us they can read the entire book in less than an afternoon. Check the book out on Amazon where it's 5-star rated, but don't buy it there. They'll charge you $25 for the book, plus shipping and handling. Order the book from us, and we only ask that you cover the cost of shipping the book to you. The book itself is free. Grab your free copy of The Law of Self-Defense Principles right now at lawofselfdefense.com/freebook.